Hey everyone, welcome to this recording of WR Migration's H-1B CAP webinar series. In it, we're focusing on a few techniques you may be able to employ should you not be accepted or not be chosen in the H-1B CAP lottery. Before we get started, we have a quick legal disclaimer for you. This does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consult with one of our attorneys. A bit more about our firm. We're a global law firm for an innovative world. This means we're a top-rated immigration law firm that provides strategic client-centered services with a laser focus on technology. Speaking of technology, Rapid is the next generation of immigration management software. It's powered by Salesforce and driven by AI, and it really works to create a more efficient, but at the same time, more responsive environment for any immigration professional or anyone working in the immigration field. If you haven't scheduled a demo and don't know anything about Rapid, I encourage you to reach out to one of our presenters who'd be happy to help you. Speaking of presenters, we have two wonderful attorneys for you today. Naveen Bhora is the managing partner at our New York offices. And just up the road, Julie Galvin is the senior associate at our Boston office. We'll go ahead and turn to Naveen first, who will be able to refresh us a little bit on what the H-1B CAP lottery is and how much of a quota is allotted to it.
Thank you, James. There is an annual quota of the H-1B, so we're just getting started into the H-1B season. The quota is basically there is a 65,000 annual limit for new H-1Bs, and then there's an additional 20,000 for people who have U.S. master's degrees. The quota is met by participating in an annual registration period, which runs in March. And then typically immigration notifies people who are selected by the last week of March or the first week of April. We've this past year have had 3 rounds of selections, which was really unusual. There was the first draw that happened end of March, beginning of April. There was another one that happened over the summer, and then we actually had a 3rd draw that happened most recently in November, which was really exciting for people. And we think that may have happened this year because there were people who had multiple H-1B registrations filed for different companies, perhaps, and many of those folks didn't actually then file H-1B petitions. Next slide, please. There are also companies and people who are considered exempt from the H-1B cap. So if you're, have the benefit of working for a university, for example, then you don't have to worry about this annual H-1B cap because these institutions or companies are considered cap exempt. Just to note though, if you are starting to work at a university on an H-1B cap, and then you want to then switch to a private company that is subject to the annual quota, then you will need to participate again in the H-1B lottery so that you can switch from that university or cap exempt institution to a cap subject employer. Another strategy may be that you could have a concurrent H-1 with a cap exempt institution such as a university, and then simultaneously work for a cap subject company. So for example, if there's a startup and it's affiliated with a university, then you could either try to show that they're cap exempt because you're working at a university, even though your employer is a private institution, or you could have 2 separate H-1Bs, one with the cap exempt and then the other one that's cap subject. An example of this would be if you're a physician working at a teaching hospital. The teaching hospital is affiliated with a medical school and therefore they are cap exempt. But then you also want to moonlight and work for a private practice, then that may be a way to concurrently work for a company that is subject to the cap, but you're also working at a cap exempt institution. Next slide, please. Okay, so now we're going to talk about, if you are exempt from the CAP, or sorry, you did not make it through the CAP selection process and you don't have a job offer with a company that is exempt from the CAP. So there are alternatives. There's a whole host of visas for foreign nationals who are from countries where there's a free trade agreement between the United States and their country. So you do have to be a citizen or national of one of these countries. The H-1B one for Chilean and Singaporean nationals, there are annual quotas for this group, but there's so few people who actually apply for the visa that the cap for these countries is actually never met. But the requirements are very similar in that it has to be a specialty occupation. And for all H-1Bs, there is a requirement for a labor condition application, and you have to show that the individual will be paid what's considered the prevailing wage for that position in a geographic location. The TN is limited to Canadians and Mexicans. It is very limited to a specific list of occupations that are found on this appendix here, 1603. So you can take a look at, the very, very defined list of occupations. The ones that we see very, often and actually come under a lot more scrutiny is the management consultant and the scientific technician technologist, because you don't have to have a degree to do the job necessarily. And with the management consultants, for example, unless you're working at a consulting firm as a professional consultant, there are people who apply as a management consultant because they're coming in to advise a company on a particular project or an initiative. And for these management consultants, you don't need to actually have a degree if you can show you have like 5 years of experience in that profession. The Canadians can just apply directly at the port of entry because there's no requirement for a Canadian to have a visa. The Mexican nationals actually have to apply for the TN visa at a US consulate in Mexico. The E1 and the E2 treaty investors and traders, those you have to make sure that there is a treaty between the United States and your country of citizenship. And the E3 is for Australians. It's very similar to the H-1B in terms of specialty occupation and needing to have the required degree. For all of these free trade agreement visas, you can actually apply directly at the consulate. You don't need to apply with USCIS Service Center in the States. So, once you have the packet ready, you can apply for your visa and then just go to the US consulate. In a lot of ways, this was much faster pre-COVID. Now with, in the last 2 years with the pandemic, it's really shut down consular processing in a lot of countries because the consular staff is working on a much more skeletal scale, and they're just not doing routine visa processing, and so it's been difficult to secure a visa appointment. And then there were regional travel restrictions from certain areas such as the Schengen area, South Africa, Brazil. And so that also added another layer of difficulty in getting the visa appointment and then securing the actual visa. You had to show that you also qualified for what was called a national interest exception. But hopefully things will go back to normal again, and it will be much easier to do a change of status to go to the consulate and get your new visa than to do a change of status in the United States. And of course, when you do it this way at the consulate, you also get the visa stamp done at the same time. All of these visas, there's no limit to how many times you can have the visa renewed, but they're all considered visas where you can't have the desire to live here permanently. So you do need to show that your ultimate intention is to return to your home country. Next slide, please. Okay, now the next visa that we want to talk about is the L1, which is the intercompany transfer visa. This is a great option if you have a job offer with a company in the US that also has an affiliate company abroad. You would spend 1 year at that affiliate company in a managerial or specialized knowledge capacity, and then you can return, transfer back to the US on an L visa. During that 1 year that you're actually on payroll with that affiliate company, you can visit the United States for business meetings, for example, but just keep in mind that any time that you're spending in the United States during that one qualifying year, we'd recommend tacking it on at the end so that you definitely have that 1 full year. Another possibility, if you're particularly entrepreneurial, is to go to a company abroad for 1 year and then help them set up a branch office or an affiliate subsidiary entity in the United States, and then you can come on what's called a new office L1. The new office Ls are a little bit challenging in that while most Ls you get it initially for 3 years, the new office L would only be for 1 year. And then you would have to show that the company's really taken off, which can be a challenge for the first year, but you do have to show that you've hired some people and the company is actually starting to do business and then get the extensions. There is a 7-year limit for the managers and executives and 5-year limit for specialized knowledge. So what that means is your first one will be for 3 years, and then after that you get 2-year renewals. Specialized knowledge can be a little bit difficult to define. It just can't be something, for example, if you're an accountant that you know how to do tax filings or audits in the United States. They really have to be what's considered proprietary to your company and some service or programs that were developed within your company, and you are coming to work on that tool or service. If the company is large enough, meaning they have at least 25 million in annual sales in the US, then they may have what's called a blanket petition, and it can be much easier to apply for the L1 visa based on the blanket, because you can just apply at the consulate and you don't have to first apply for a petition with USCIS. So that can be great for the companies that have the blanket. Do you want to add anything to the L discussion?
No, I just heard the tail end of it, but I'm sure you covered it beautifully.
Okay.
Thank you, Naveen.
So why don't you go on to the next one?
I would love to. Okay, so we're on the O's. Okay, so another good option for certain people, particularly researchers or people with really strong credentials, could be the O1, also performers. So it's for the alien of extraordinary ability in art, science, education, sports, and actually business as well. So it does cover a lot of fields. It can be a good option for a startup because they can, as long as you can show that you have an employer-employee relationship, a new company can sponsor an O1, but you would need to be able to show that there's that level of control over your work from the company. But you do have to meet, it's a pretty high standard. You do have to show that you're at the very top of the field. Generally, we look at that by looking at whether the person has major awards, whether there's press about them, whether they meet a high salary in relation to others in their field, whether they made critical significant achievements in the field that are original, or they've held a position that is critical with a company with an outstanding reputation. But there is some flexibility with that. So if there's, maybe one of those don't fit the field, if there's other documentation to show that this person's really extraordinary, that can potentially qualify them for that. And for artists, they can show that by the amount of revenue they're bringing into their shows, any types of exhibits that they're doing. So there is some creativity with the O, but you do have to be at the top of the field. I can take this one too. So another option that we often see are people that decide they want to stay in school. So you can extend your practical training if you can extend your F1 program into a program that allows for day one curricular practical training, or what we call CPT. The program itself must be related to the job that you'll be working in, and it has to be signed off by the school, but it should be different than the degree that you've already earned. So oftentimes we see this in, say, project management, for example, because that is a degree program that might nicely complement a lot of other fields without duplicating, of computer science masters, for example. In order to do this, though, it is maintaining F1 status. So you do have to basically commit to the program. So pay tuition, attend the courses, and then keep that full course of study to make sure you're complying with all your F1 visa requirements. And we do warn, proceed with caution. While this is permissible, this is something, though, that USCIS, particularly over in recent years, we have seen them question whether this is proper, whether the curricular practical training is integral to the degree program, whether the foreign national has properly maintained their status. So we always tell people it's very important to maintain all of their documentation. So not just your I-20 forms, but your syllabi, course ID, travel. A lot of these are more executive type programs, or maybe you will travel once a month to take a course in person, and the rest of the time it's more online or more hands-on. So travel records, everything related to the course should be maintained. So that is an option if somebody's really committed to furthering their education, and it also complements their career path. Do you want me to take this one too, Naveen?
Yeah, why not?
Oh, sure, sure. So in certain cases, maybe we can't find a good non-immigrant visa option for you, or you're just really great wanting to move forward to the green card. And so this can be possible. There are several ways that we can do that. The most common way is testing the labor market, the traditional method of PERM or labor certification. That does require that there's an employer sponsor. And it can take some time. So there's several steps that we need to do before we're even able to file the case. It can take about 9 months just to file, and really to get your priority date, to get in line for that in the visa queue, it can take up to 18 months or even 2 years to get to the I-140 stage or approval, where that priority date is locked in for you. And whether some people, depending on country of birth, may be able to apply right away for their adjustment of status. So if you're not from a backlog country and you're early on in your F1, that could be an option. There's outstanding researchers, which are another employment-based petition. So you need to be able to show that, again, you're at the very top of your field. The criteria is similar to the O1, but we only need to meet 3 criteria. But if you're working for either an academic institution or a private employer that traditionally hires researchers, so if they have at least 3 full-time researchers and they have accomplishments in the field, then a private employer may be able to sponsor as well for an outstanding researcher. The nice thing about that is it puts you in the EB1 category, which, if you are from a backlog country, right now is current across the board. So you wouldn't have to worry about that 2-year wait just to get through those steps before you're able to file for your adjustment of status. The other is self-petition. Certain people might have credentials that are such that they're that strong that they can just petition on their own, and they don't necessarily need a job offer, but they need to be able to show that they're going to continue to work in their field. So there's the EB1A, which is alien of extraordinary ability, similar again to the O, except on the green card route. And it's a bit of an even higher standard, because not only do we have to show you meet criteria, at least 3 criteria, but you do need to be able to show that in meeting those criteria, you are at the very top of your field. So it's a 2-tier analysis, they call it. But there are some advantages. It's the EB1 category, so you're not necessarily subject to the backlog as long as there's no visa retrogression. You don't necessarily need an employer sponsor. So that timing-wise will get is going to be favorable to a lot of people. Then there's the national interest waiver, which again, You can, or you don't need to be employer sponsored. You need to be able to show that your work is going to be, it's important and it's in the national interest. It's a little bit more of a subjective standard. But we still look to a lot of those same qualifying criteria, publications, awards, et cetera, to show why it's important that you do this work. Certain people might be able to, if you have family that can sponsor you. Generally speaking, family petitions can take quite a long time unless you're married to a US citizen. So if you're an immediate relative or a parent of, but the child would have to be at least 21 to sponsor. So that's probably going to be somewhat limited, but it's worth looking at that option in certain cases. But when you're looking at the green card, I think there are certain things to keep in mind, because it doesn't, if you don't have that nice bridge like an H-1B or an L-1 that allows you to have that intent to immigrate, we do have to look at timing. Will you time out of your F1 program before you're able to get to the green card, and how will that affect? Will you need to leave the country? Will you have a gap in employment authorization? Intent issues, because a lot of these non-immigrant visa options don't allow you to have the intent to immigrate. It's possible to do it, but it's a bit more tricky when you come to travel and timing of extensions, et cetera. There's also the ability to consular process that can take some time. So I don't want to go too deep into, there's so much we can talk about this. So if there's other questions, we can certainly get to those. And then travel obviously is always a consideration in the immigration process. For the green card, depending on how you're going to go through the process. So if you're doing the traditional route of labor certification, you can travel throughout PERM. Once you get to that stage where we're able to file your adjustment of status, you would have to be in the United States. And if you're in F1 status, then you would not be able to depart until you have a travel document. So there's some limitations there it's important to be aware of. So all possibilities, but you just need to look very closely at your situation to see what is going to make the most sense there.
Thank you, Julie. So we do have one question from our audience. It was about concurrent H-1Bs or full-time versus part-time. So whenever there's a change in your position, so if there's a change in the job duties or there's a promotion, we need to see if it's considered a material change. And immigration does take the position that if you're going from a full-time petition or position to a part-time, then that is considered a material change, and you would need to file an amended petition to inform immigration, the Department of Labor, that that your position is now on a part-time basis. Sometimes, if you do part-time petitions, they are structured so that it's an hourly rate of pay instead of an annual. And so you would put the hourly rate, and then you would put a range of hours per week. So it could be 20 to 40, and that may give you the flexibility of working a full 40-hour week when needed. So that might be the way to go from part-time to a more full-time schedule without having to file an amended petition. But certainly if you're going from full-time to part-time, then that would be considered a material change that would require an amended filing. James, do we have any other questions?
Yes, we do have a few more. Let's see. Perhaps we direct this one to Julie. What is considered an H-1B exempt affiliated institution? Can you give me an example?
Sure. So universities are considered exempt, and anything that is associated with them in the sense that they have either shared ownership, control, or operated by, or have a written agreement, like an affiliation agreement. So for example, a teaching hospital in a lot of cases would satisfy that criteria. I've done a case before where it was an independent school that we were trying to explore ways to get them to hire somebody outside the H-1B quota cycle. And turns out they did have an affiliation agreement with a college for internship. And if you can show that that affiliation, if the private entity's relationship is going towards the mission of that nonprofit, so like the university, and in this case it was to help with the teaching program, you can qualify as cap exempt.
Great. Okay. I have another question here. Perhaps I direct it to Naveen. For the L1A visa, do you have to be a manager during your year abroad, or do you have to be a manager in time to return to the US?
That's a great question. So for the L1, which is the temporary work visa, you could have a specialized knowledge position outside the United States at the affiliate company, and then a managerial position in the United States for the L1A. However, Julie had mentioned some of the green card processes, and one of them is what we refer to as EB1C, which is a green card process for intercompany transfer, similar to the L1. But for that category, you do need to have had a managerial position at the affiliate office abroad. If you didn't, if you had only the specialized knowledge position, then the way to get the green card then would be through a perm labor certification.
Great. Okay. Follow up for Julie here. What is the criteria for startup to apply for the O1?
So this, for an O1 startup, you would just need to be able to show that it is a corporate entity. So, and you also have to be able to show that there is that level of control over the beneficiary. So if there's a board, for example, so basically if you can't be self-employed, so you need to be able to have that distinction to show that there's somebody that is overseeing your work, essentially.
Got it. Okay. So we have perhaps, do you guys have time for one more question, and then we can close it here?
Sure. Yeah.
Great. Okay. With CPT, what will be the status of family?
So they would remain in F2 status.
Okay. Great. Nice and brief.
Yeah, no, James, actually, I wanted to mention, when we were talking about the L's and the E's, and actually H4s, there was a case where USCIS was sued over this on the employment authorization cards, that the spouses of E and L, and in some cases H-1B workers, their spouses can get work authorization. It's called an employment authorization document. And the latest and greatest is that immigration has agreed that you don't need the work authorization card to work if you're an E2 or E1 or E3 spouse or L2 spouse. It's just incident to status. So as long as your spouse comes in on that status, you should be work authorized without having to wait for that work card. Immigration did say that they're waiting for the Customs and Border Protection to update the way I-94 records are annotated, so that once that happens, then definitely there is a way for employers to complete the Form I-9, which is the Employment Eligibility Verification Form for those spouses. So that's a great option, even though you may not want to go abroad for a year and come back on an L. The benefit is that your spouse who would come on the L2 would have that work authorization. So I just wanted to mention that.
Great, thank you. Naveen, perhaps you can close us out here.
Oh, great. All right. So our contact information is there, and please do reach out to myself or Julie or any of our attorneys at one of our offices, depending on where you are geographically. And our webinar is recorded and available on YouTube. Thank you so much for attending today.
Yeah, thank you all.